580-104. Remedies cumulative. Remedies provided by this article are cumulative and do not affect the availability of remedies under other law or the recognition of a foreign support order on the basis of comity. B. This article does not 1. Provide the exclusive method of establishing or enforcing a support order under the law of this state, or 2. Grant a tribunal of this state jurisdiction to render judgment or issue an order relating to child custody or visitation in a proceeding under this article. 580-105. Application of the article to a resident of a foreign country and foreign support proceedings. A tribunal of this state shall apply parts 1 through 6 of this article and, as applicable, Part 7 of this article, to a support proceeding involving 1. A foreign support order, 2. A foreign tribunal, or 3. An obligee, obligor, or child residing in a foreign country. B. A tribunal of this state that is requested to recognize and enforce a support order on the basis of comity may apply the procedural and substantive provisions of Parts 1 through 6 of this article. C. Part 7 of this article applies only to a support proceeding under the Convention. In such a proceeding, if a provision of Part 7 of this article is inconsistent with Parts 1 through 6 of this article, Part 7 of this article controls. 580-201. Bases for jurisdiction over non-resident. In a proceeding to establish or enforce a support order or to determine parentage of a child, a tribunal of this state may exercise personal jurisdiction over a non-resident individual or the individual's guardian or conservator if 1. The individual is personally served with a summons and petition within this state. 2. The individual submits to the jurisdiction of this state by consent, by entering a general appearance, or by filing a responsive document or other action having the effect of waiving any contest to personal jurisdiction. 3. The individual resided with the child in this state. 4. The individual resided in this state and provided prenatal expenses or support for the child. 5. The child resides in this state as a result of the acts or directives of the individual. 6. The individual engaged in sexual intercourse in this state and the child may have been conceived by that act of intercourse. 7. The individual asserted parentage of a child in the putative father registry maintained in this state by the Office of Children and Family Services. Or 8. There is any other basis consistent with the constitutions of this state and the United States for the exercise of personal jurisdiction. B. The basis of personal jurisdiction set forth in subdivision of this section or in any other law of this state may not be used to acquire personal jurisdiction for a tribunal of this state to modify a child support order of another state unless the requirements of Section 580-611 of this article are met, or, in the case of a foreign support order, unless the requirements of Section 580-615 of this article are met. 580-202. Duration of personal jurisdiction. Personal jurisdiction acquired by a tribunal of this state in a proceeding under this article or other law of this state relating to a support order continues as long as a tribunal of this state has continuing exclusive jurisdiction to modify its order or continuing jurisdiction to enforce its order as 580-203. Initiating and responding tribunal of state. Under this article, a tribunal of this state may serve as an initiating tribunal to forward proceedings to a tribunal of another state, and as a responding tribunal for proceedings initiated in another state or a foreign country. 580-204. Simultaneous proceedings. A tribunal of this state may exercise jurisdiction to establish a support order if the petition or comparable pleading is filed after a pleading is filed in another state or a foreign country only if 1. The petition or comparable pleading in this state is filed before the expiration of the time allowed in the other state or the foreign country for filing a responsive pleading challenging the exercise of jurisdiction by the other state or the foreign country. 2. The contesting party timely challenges the exercise of jurisdiction in the other state or the foreign country. And 3. If relevant, this state is the home state of the child. B. A tribunal of this state may not exercise jurisdiction to establish a support order if the petition or comparable pleading is filed before a petition or comparable pleading is filed in another state or a foreign country if 1. The petition or comparable pleading in the other state or foreign country is filed before the expiration of the time allowed in this state for filing a responsive pleading challenging the exercise of jurisdiction by this state. 2. The contesting party timely challenges the exercise of jurisdiction in this state. And 3. If relevant, the other state or foreign country is the home state of the child. 580-205. Continuing exclusive jurisdiction to modify child support order. A tribunal of this state that has issued a child support order consistent with the law of this state has and shall exercise continuing exclusive jurisdiction to modify its child support order if the order is the controlling order and 1. At the time of the filing of a request for modification this state is the residence of the obligor, the individual obligee or the child for whose benefit the support order is issued, or 2. Even if this state is not the residence of the obligor, the individual obligee or the child for whose benefit the support order is issued, the parties consent in a record or in open court that the tribunal of this state may continue to exercise jurisdiction to modify its order. B. A tribunal of this state that has issued a child support order consistent with the law of this state may not exercise continuing exclusive jurisdiction to modify the order if 1. All of the parties who are individuals file consent in a record with the tribunal of this state that a tribunal of another state that has jurisdiction over at least one of the parties who is an individual that is located in the state of residence of the child may modify the order and assume continuing exclusive jurisdiction, or 2. Its order is not the controlling order. C. If a tribunal of another state has issued a child support order pursuant to the Uniform Interstate Family Support Act or a law substantially similar to that act which modifies a child support order of a tribunal of this state, tribunals of this state shall recognize the continuing exclusive jurisdiction of the tribunal of the other state. D. A tribunal of this state that lacks continuing exclusive jurisdiction to modify a child support order may serve as an initiating tribunal to request a tribunal of another state to modify a support order issued in that state. E. A temporary support order issued ex parte or pending resolution of a jurisdictional conflict does not create continuing exclusive jurisdiction in the issuing tribunal.
Okay, I'm going to just back up a bit. So, 205, continuing exclusive jurisdiction. A tribunal of the state that has issued an order and has continuing exclusive jurisdiction, they can modify it if the order is the controlling order. So that's 1. Order is the controlling order. And 2, if at the time of the filing of a request for modification, this state is the residence of obligor, obligee, or child. Or, even if this state is not the residence of any of those people, they consent in a record or an open court that the tribunal may exercise jurisdiction to modify the order. B. Then it goes on to say that even if New York issued the support order, they may not continue to exercise exclusive original jurisdiction to modify it if 1. All the parties consent in a record that another state has, may modify it, and at least one of the parties that's an individual or that's located in the state of residence of the child may modify the order. Or this order in New York is not the controlling order. If a tribunal of another state issued a support order pursuant to UIFSA, this state shall recognize the continuing exclusive jurisdiction of the other state. A tribunal that in New York that lacks such jurisdiction to modify may serve as an initiating tribunal to request another tribunal of another state modify a support order in that state. A temporary support order issued ex parte or pending resolution of a jurisdictional conflict does not create continuing exclusive jurisdiction in the issuing tribunal.
580-206. Continuing jurisdiction to enforce child support order. A tribunal of this state that has issued a child support order consistent with the law of this state may serve as an initiating tribunal to request a tribunal of another state to enforce 1. The order if the order is the controlling order and has not been modified by a tribunal of another state that assumed jurisdiction pursuant to the Uniform Interstate Family Support Act, or 2. A money judgment for arrears of support and interest on the order accrued before a determination that an order of a tribunal of another state is the controlling order. B. A tribunal of this state having continuing jurisdiction over a support order may act as a responding tribunal to enforce the order. 580-207. Determination of controlling child support order. If a proceeding is brought under this article and only one tribunal has issued a child support order, the order of that tribunal controls and must be recognized. B. If a proceeding is brought under this article, and two or more child support orders have been issued by tribunals of this state, another state or a foreign country with regard to the same obligor and same child, a tribunal of this state having personal jurisdiction over both the obligor and individual obligee shall apply the following rules and by order shall determine which order controls and must be recognized. 1. If only one of the tribunals would have continuing, exclusive jurisdiction under this article, the order of that tribunal controls. 2. If more than one of the tribunals would have continuing, exclusive jurisdiction under this article, I. An order issued by a tribunal in the current home state of the child controls, or II. If an order has not been issued in the current home state of the child, the order most recently issued controls. 3. If none of the tribunals would have continuing, exclusive jurisdiction under this article, the tribunal of this state shall issue a child support order, which controls. C. If two or more child support orders have been issued for the same obligor and same child, upon request of a party who is an individual that is a support enforcement agency, a tribunal of this state having personal jurisdiction over both the obligor and the obligee who is an individual shall determine which order controls under subdivision B of this section. The request may be filed with a registration for enforcement or registration for modification pursuant to Part 6 of this article, or may be filed as a separate proceeding. D. A request to determine which is the controlling order must be accompanied by a copy of every child support order in effect and the applicable record of payments. The requesting party shall give notice of the request to each party whose rights may be affected by the determination. E. The tribunal that issued the controlling order under subdivision A, B, or C of this section has continuing jurisdiction to the extent provided in section 580-205 or 580-206 of this part. F. A tribunal of this state that determines by order which is the controlling order under paragraph 1 or 2 of subdivision B, or subdivision C of this section, or that issues a new controlling order under paragraph 3 of subdivision B of this section, shall state in that order, 1. The basis upon which the tribunal made its determination, 2. The amount of prospective support, if any, and 3. The total amount of consolidated arrears and accrued interest, if any, under all of the orders after all payments made are credited as provided by section 580-209 of this part. G. Within 30 days after issuance of an order determining which is the controlling order, the party obtaining the order shall file a certified copy of it in each tribunal that issued or registered an earlier order of child support. A party or support enforcement agency obtaining the order that fails to file a certified copy is subject to appropriate sanctions by a tribunal in which the issue of failure to file arises. The failure to file does not affect the validity or enforceability of the controlling order. H. An order that has been determined to be the controlling order, or a judgment for consolidated arrears of support and interest, if any, made pursuant to this section must be recognized in proceedings under this article. 580-208. Child support orders for two or more obligees. In responding to registrations or petitions for enforcement of two or more child support orders in effect at the same time with regard to the same obligor and different individual obligees, at least one of which was issued by a tribunal of another state or a foreign country, a tribunal of this state shall enforce those orders in the same manner as if the orders had been issued by a tribunal of this state. 580-209. Credit for payments. A tribunal of this state shall credit amounts collected for a particular period pursuant to any child support order against the amounts owed for the same period under any other child support order for support of the same child issued by a tribunal of this state, another state, or a foreign country. 580-210. Application of article to non-resident subject to personal jurisdiction. A tribunal of this state exercising personal jurisdiction over a non-resident in a proceeding under this article, under other law of this state relating to a support order, or recognizing a foreign support order may receive evidence from outside this state pursuant to section 580-316 of this article, communicate with a tribunal outside this state pursuant to section 580. 317 of this article and obtain discovery through a tribunal outside this state pursuant to section 580-318 of this article. In all other respects, parts 3 through 6 of this article do not apply, and the tribunal shall apply the procedural and substantive law of this state.
All right, so this says New York Family Court exercising personal jurisdiction over a non-resident relating to a support order or recognizing a foreign support order may receive evidence from outside New York, communicate with a tribunal outside New York, and obtain discovery through a tribunal outside New York. In all other respects, this article does not apply, and family court shall use regular New York law.
(580-211). Continuing exclusive jurisdiction to modify spousal support order. A tribunal of this state issuing a spousal support order consistent with the law of this state has continuing exclusive jurisdiction to modify the spousal support order throughout the existence of the support obligation. B. A tribunal of this state may not modify a spousal support order issued by a tribunal of another state or a foreign country having continuing exclusive jurisdiction over that order under the law of that state or foreign country. C. A tribunal of this state that has continuing exclusive jurisdiction over a spousal support order may serve as 1. An initiating tribunal to request a tribunal of another state to enforce the spousal support order issued in this state, or 2. A responding tribunal to enforce or modify its own spousal support order. (580-301). Proceedings under Article except as otherwise provided in this article. This part applies to all proceedings under this article. B. An individual petitioner or a support enforcement agency may initiate a proceeding authorized under this article by filing a petition in an initiating tribunal for forwarding to a responding tribunal or by filing a petition or a comparable pleading directly in a tribunal of another state or a foreign country which has or can obtain personal jurisdiction over the respondent. 580-302. Proceeding by a minor parent. A minor parent, or a guardian or other legal representative of a minor parent, may maintain a proceeding on behalf of or for the benefit of the minor's child. 580-303. Application of law of state. Except as otherwise provided in this article, a responding tribunal of this state shall 1. Apply the procedural and substantive law generally applicable to similar proceedings originating in this state and may exercise all powers and provide all remedies available in those proceedings, and 2. Determine the duty of support and the amount payable in accordance with the law and support guidelines of this state. 580-304. Duties of initiating tribunal. Upon the filing of a petition authorized by this article, an initiating tribunal of this state shall forward the petition and its accompanying documents 1. To the responding tribunal or appropriate support enforcement agency in the responding state, or 2. If the identity of the responding tribunal is unknown, to the state information agency of the responding state with a request that they be forwarded to the appropriate tribunal and that receipt be acknowledged. B. If requested by the responding tribunal, a tribunal of this state shall issue a certificate or other document and make findings required by the law of the responding state. If the responding tribunal is in a foreign country, upon request the tribunal of this state shall specify the amount of support sought, convert that amount into the equivalent amount in the foreign currency under applicable official or market exchange rate as publicly reported, and provide any other documents necessary to satisfy the requirements of the responding foreign tribunal. 580-305. Duties and powers of responding tribunal. When a responding tribunal of this state receives a petition or comparable pleading from an initiating tribunal or directly pursuant to subdivision B of section 580-301 of this part, it shall cause the petition or pleading to be filed and notify the petitioner where and when it was filed. B. A responding tribunal of this state, to the extent not prohibited by other law, may do one or more of the following. 1. Establish or enforce a support order, modify a child support order, determine the controlling child support order or determine parentage of a child. 2. Order an obligor to comply with a support order, specifying the amount and the manner of compliance. 3. Order income withholding. 4. Determine the amount of any arrearages, and specify a method of payment. 5. Enforce orders by civil or criminal contempt, or both. 6. Set aside property for satisfaction of the support order. 7. Place liens and order execution on the obligor's property. 8. Order an obligor to keep the tribunal informed of the obligor's current residential address, electronic mail address, telephone number, employer, address of employment and telephone number at the place of employment. 9. Issue a warrant for an obligor who has failed after proper notice to appear at a hearing ordered by the tribunal and enter the warrant in any local and state computer systems for criminal warrants. 10. Order the obligor to seek appropriate employment by specified methods. 11. Award reasonable attorney's fees and other fees and costs. And 12. Grant any other available remedy. C. A responding tribunal of this state shall include in a support order issued under this article, or in the documents accompanying the order, the calculations on which the support order is based. D. A responding tribunal of this state may not condition the payment of a support order issued under this article upon compliance by a party with provisions for visitation. E. If a responding tribunal of this state issues an order under this article, the tribunal shall send a copy of the order to the petitioner and the respondent and to the initiating tribunal, if any. F. If requested to enforce a support order, arrears, or judgment or modify a support order stated in a foreign currency, a responding tribunal of this state shall convert the amount stated in the foreign currency to the equivalent amount in dollars under the applicable official or market exchange rate as publicly reported. (580-306). Inappropriate tribunal. If a petition or comparable pleading is received by an inappropriate tribunal of this state, the tribunal shall forward the pleading and accompanying documents to an appropriate tribunal of this state or another state and notify the petitioner where and when the pleading was sent. (580-307). Duties of Support Enforcement Agency. A support enforcement agency of this state, upon request, shall provide services to a petitioner in a proceeding under this article. B. A support enforcement agency of this state that is providing services to the petitioner shall 1. Take all steps necessary to enable an appropriate tribunal of this state, another state or a foreign country to obtain jurisdiction over the respondent. 2. Request an appropriate tribunal to set a date, time and place for a hearing. 3. Make a reasonable effort to obtain all relevant information, including information as to income and property of the parties. 4. Within 10 days, exclusive of Saturdays, Sundays and legal holidays, after receipt of notice in a record from an initiating, responding or registering tribunal, send a copy of the notice to the petitioner. 5. Within 10 days, exclusive of Saturdays, Sundays and legal holidays, after receipt of communication in a record from the respondent or the respondent's attorney, send a copy of the communication to the petitioner. And 6. Notify the petitioner if jurisdiction over the respondent cannot be obtained. C. A support enforcement agency of this state that requests registration of a child support order in this state for enforcement or for modification shall make reasonable efforts. 1. To ensure that the order to be registered is the controlling order, or 2. If 2 or more child support orders exist and the identity of the controlling order has not been determined, to ensure that a request for such a determination is made in a tribunal having jurisdiction to do so. D. A support enforcement agency of this state that requests registration and enforcement of a support order, arrears or judgment stated in a foreign currency shall convert the amounts stated in the foreign currency into the equivalent amounts in dollars under the applicable official or market exchange rate as publicly reported. E. A support enforcement enforcement agency of this state shall issue or request a tribunal of this state to issue a child support order and an income withholding order that redirect payment of current support, arrears, and interest if requested to do so by a support enforcement agency of another state pursuant to Section 580-319 of this Part F. This article does not create or negate a relationship of attorney and client or other fiduciary relationship between a support enforcement agency or the attorney for the agency and the individual being assisted by the agency.